What was supposed to be a routine court hearing suddenly turns into complete chaos when a defendant accused of making a terroristic threat walks in expecting to wrap things up with a plea deal. At first, Ronald Allen presents himself as calm and cooperative, even describing himself as a reasonable guy caught in a messy custody battle. But within moments, the judge notices something in the paperwork that stops the entire courtroom in its tracks. Hidden inside the documents is a protective order that doesn't just name Allen's ex-wife, it also lists his own former custody attorney as a protected person. The discovery creates instant tension. The judge is visibly concerned, the defense looks confused, and no one in the courtroom seems able to explain how or why that attorney ended up on the order. As the hearing continues, the confusion only deepens. The defense attorney struggles to clarify the situation, insisting that only the ex-wife is actually protected, while the official paperwork suggests otherwise. The judge refuses to take any risks, making it clear that she will not proceed with sentencing until she is absolutely certain that no court order will be violated and no one's safety will be compromised. What follows is an unexpected twist. Rather than being sentenced that day, the defendant walks out of the courtroom, with the hearing postponed until the civil court can provide clear answers. In a case involving serious criminal charges and the possibility of years in prison, the outcome shocks everyone watching. This isn't just a story about a threat, it's a perfect example of how one confusing document can bring the entire justice system to a halt.
Charles W. Booker for the accused. Ronald Allen.
All right. Counsel, you received all discovery?
Yes, I did, Judge.
All right. You're charged with a terroristic threat of a public servant or placing the public in fear of serious bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to the $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. Did you intend to give up those rights and enter into a plea in this case?
I did.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
I understand.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Allen, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you a U.S. citizen? I'm sorry, not a U.S. citizen. That's not allowed to be asked anymore. Did you understand by entering in this plea, you could, if you're not a citizen, you could be deported, not allowed to re-enter the United States or denied naturalization. Did you understand?
I do.
Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. Did you understand that to be the plea?
I did.
Defense?
Yes, that's true.
State?
Yes, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Charles Ireland or Mark Metley. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State tenders what has been marked States Exhibit 1 and all attachments.
Court will accept into evidence States Exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right. Anything you wish to say on behalf of your client?
Yes, Judge. Last night, I electronically filed a sentencing memorandum. I think it's been accepted by the court, and I wanted to provide it to you along with the attachments.
All right. Any objections to the court reviewing? Okay. All right. Yes.
And so, Judge, as you can see, essentially what primary reason and the desire for Mr. Allen is that he be able to continue with supervised access to his son, Aiden. As you can see in the attachments there, the civil trial court did understand that Mr. Allen would have supervised access to his son, both in San Antonio as well as North Texas. Additionally, we do know that on the 22nd, we received a letter from Thomas Villalobos, an update letter regarding bond conditions. That letter also attached had the Center for Healthcare Services finding that they had met with Ronald Allen to complete an intake for mental health services and that he hadn't met criteria for qualifying mental health diagnoses at that time. The largest thing that matters the most to Mr. Allen and his family is that his GPS permit him to be monitored. That's fine if that's what the court desires, but he would like to be able to move freely about the state, to be able to see his son from time to time, attend his father's services, and help his mother maintain his father's properties. And so that is the primary thing. We totally agree with no contact with either Michael Ireland or Mark Medley. That's new to me, but he's fine not staying away from that man too.
Based upon the judge's notes that you presented to the court, those are people that are listed under the protective order. And there's a third person, it appears, well, there are two other people. It appears to be either this is Gallegos, and then they have Ramirez, and Ramirez is listed as the amicus attorney.
Okay, Judge, those are not, those are other litigants that were also in the judge's notes. Ms. Gallegos is actually here in the court, and she's the custody lawyer for Mr. Allen.
I'm just saying, the judge's notes that you gave me, they have these people listed underneath protective order.
As the judge continues reviewing the documents, the entire courtroom grows noticeably quiet, sensing that something is seriously wrong. She pauses, looks back down at the protective order, and begins asking pointed questions that no one seems fully prepared to answer. The defense attorney shuffles through papers, trying to clarify that only the defendant's ex-wife is meant to be protected, but the written order clearly lists additional names, including the very attorney who once represented the defendant in his custody battle. That contradiction raises a dangerous possibility. If the court proceeds without resolving this, the defendant could unknowingly violate an existing protective order the moment he leaves the courtroom. The judge refuses to take that risk. Her tone becomes firmer as she explains that the court cannot move forward on assumptions or unclear records, especially in a case involving threats and family disputes. What was moments ago a routine plea hearing now feels like a legal minefield, with every word and signature on the paperwork carrying serious consequences. The confusion spreads across the room, and it becomes obvious that this hearing is no longer under anyone's control. It's now a race to untangle conflicting court orders before a single wrong step leads to even bigger legal trouble.
State, I've overstepped my bounds. Do you have any objections to his going to his father's services? All right. So what your attorney will need to do is I will print here a page with an order, and I will do the style, and you all need to write down your agreement.
Okay.
All right.
Absolutely. Thank you.
So you're welcome. So Ms. Ferguson,
Yeah.
when can we bring this back? And when it come back, I will need specifically what the judge is saying on the civil side.
Yes.
So that this could a little bit be in harmony.
Absolutely. I agree.
All right, the 16th, is that enough time for you counsel to have everything ready?
Yes, of course, Judge. And I want you to know that the civil court is waiting for the outcome of this case
All right.
in order to make their orders, and that's one of the reasons Ms. Gallegos is.
All right. Hello, how are you doing?
Yeah. Good, how are you?
Good seeing you.
Good to see you.
So anyway, it appears the documentation that I've received that has the judge's notes,
Mhm.
the way it's written, it appears that you're a part of the protective order. Metley is a part of the protective order. So if the court can get clarification from the judge
Okay.
on that side about who is really included in the protective order and what they are doing with the visitation, that will be greatly appreciated.
Okay, we have a conference call next week, and then we will be looking to get it entered. We are hoping to obviously do it as soon as possible, and we will try to meet your deadline of the 16th. And I'll let the other attorneys know. If not, do we need to send an email to Ms. Ferguson?
No, I mean,
Okay.
so I'll just need that information before the 16th. So if you all can get the judge to, if you all want to, you can have the judge email me and
Okay.
say, this is who's a part of the protective order, or if there's a document, can you pass me that sheet of paper? Or if there's a document that tells me, this is the part of protective order, because the way the judge's notes are written, it's so,
Okay.
oh, you know what? I'm sorry. I need to add this.
So normally on the civil side, Mr. Medley is first because he's the petitioner. Margaret Gallegos, me, I represented the respondent, and then Anna Ramirez was the amicus.
Yeah, no,
and then it goes down.
The reason why I say that is because in the plea bargain agreement, even though it's outside their plea bargain agreement, Medley is mentioned. I'm sorry, can I have that printout one more time? So that's why I need clarification, because the way that's written in the judge's notes, as you can see, it has a title protective order. Then it has a list of 3 people. Then underneath that list, then it comes back with a 2-year protective order. So it seems as though those are the people that he has a protective order against. So I would prefer that he know, I would prefer that I know, and probation knows.
So on here it says 2-year protective order granted as to Mrs. Allen.
Yeah, but above it, it says protective order.
Okay.
So if you all will fill in the dates for him, please, and what you all have agreed on as far as his ability to go to his father's services. So that sheet of paper, if you can just put in the agreed times where he can travel for his father's services.
Okay, I'll do that now.
All right. And if you all will confirm that, and then we will come back. Norma, you said the 16th?
Yes, ma'am.
All right. So we'll come back on September 16th. And at that time, I will enter my order. And we're back on the record, Cindy. And counsel, it's the court's understanding you're waiving PSI and TAP evaluation.
I would.
All right. So thank you.
Thank you, Judge.
All right.
Thank you.
Thank you.
Thank you so much.
As the courtroom empties, the weight of what just happened becomes clear. Ronald Allen came expecting a resolution, but instead he walks out with his future still uncertain. A single protective order, buried in the paperwork, was enough to halt the entire hearing. The judge's refusal to move forward without absolute clarity wasn't just procedural, it was a necessary step to ensure no one's safety is compromised. For everyone involved, questions remain. The protective order's details are unclear, visitation rights are uncertain, and the next steps depend entirely on civil court clarification. Allen now faces the pressure of waiting for a hearing that could drastically change his life, knowing that the stakes are higher than ever. What makes this case so remarkable is how quickly control shifted. Lawyers struggled to explain the documents, the judge had to pause proceedings, and the defendant found himself caught in a web of conflicting orders he may not have fully understood. When the hearing resumes, every decision will carry serious consequences, proving that in the courtroom, even a small detail can have enormous impact. The outcome is still unknown, and until the next hearing, this case remains a tense reminder that the legal system can turn on a single line of paperwork, leaving everyone involved on edge and the story far from over.